In this segment, I'm going to be sharing with you how the footwear that you were wearing at the time of your falling accident could affect the outcome of your case. One of the most common calls we receive from prospective clients with respect to personal injury claims is an accident involving a fall. And that can take place in a multitude of ways, typically because someone has slipped on ice or snow or some other slippery substance. Perhaps they've tripped over something, surface discontinuity where perhaps a slab of a sidewalk is higher one to the adjacent one. It could be someone losing balance going up or down stairs, or perhaps they stepped in a hole in a parking lot. The common feature in all of these is that the premises were not maintained in a safe state, which led to the falling accident taking place. One of the arguments that the defense will use in trying to apportion some of the liability back to you as the accident victim is to say that you did something that you ought not to have, or that you didn't do something that you should have. And one of those common suggestions concerns the footwear that you were wearing at the time of your fall. Because if you were wearing inappropriate footwear, then you really did contribute to your own injuries by your own neglect to wear footwear that would be appropriate under the circumstances. If our client slipped on snow and ice, questions will emerge as to whether they were wearing winter boots. But if they weren't wearing winter boots, would winter boots have made a difference? What was the condition of the tread of that footwear? Were the shoes or boots old or new? Did they provide good ankle support or not? Which can be particularly relevant if you step in a hole. But what would you decide if you were on a jury hearing a case and the fact situation was that the accident victim stepped on sheer black ice? You would think perhaps that no matter what kind of footwear was being worn, whether it was winter boots or not, that the footwear likely wouldn't have prevented the fall from taking place. If alternatively you fell indoors, the same questions are asked as to whether there was good treads on your shoes, whether there was a good coefficient factor into play as to whether that tread would give you the ability to be able to walk in such a fashion that you don't easily lose your footing on a wet floor. Some of the things that we see quite often are when someone will fall inside and they were wearing sandals or they were wearing flip-flops. Does that kind of footwear really matter to the outcome of the case? There have been actually a number of court decisions that have resulted in cases across Canada. I'll tell you about a couple of them and what judges have said about wearing of flip-flops. There was a case in 2008 in the Maritimes called Miller and Royal Bank. It was a slip and fall case, and the plaintiff was wearing flip-flops in a bank that they went into. And an expert report was given by an expert that was hired by the defense that argued that the plaintiff, the accident victim, was contributory negligent because they were wearing flip-flops. And in that case, the trial judge, LeBlanc, said this, quote, "While they may have provided somewhat less slip resistance than most of the other shoes tested, I'm not satisfied that this establishes that they were more slippery than shoes generally. I reject any suggestion arising from Dr. Smith's evidence that a bank customer should be held to be contributory negligent for wearing shoes that do not give the same slip resistance as footwear with the maximum slip resistance." In another case in 2004 that took place in Toronto, a plaintiff tripped and fell over a sidewalk with a height differential of 3/4 of an inch. The court in that case found that the plaintiff contributorily was negligent for their own injuries by a factor of 75% because she was familiar with the area, knew that there were construction cuts, and had walked by them earlier, and had flip-flop shoes on, and was carrying a 2-year-old grandchild, which prevented her from seeing where she was going. So in that case, for example, the fact that she was wearing flip-flops may have factored into why the plaintiff was held to be so contributory liable to their injuries. In an old decision over 30 years ago in British Columbia, Burnett, the court in British Columbia suggests that the quality or safety level of the shoe is a major factor in determining liability. In that case, the court drew an inference that there had been water on the floor of a grocery store because an employee was spraying vegetables. And the high-heeled shoes worn by the plaintiff were described by the court as shoes that women would term sensible shoes, with a broad heel that was not excessively high. The plaintiff was also pushing a grocery buggy that would have given her some additional support, and that plaintiff was held not to be contributory liable in that case. In a decision in the City of London in 1999, a plaintiff was wearing running shoes when they slipped on a patch of ice in a parking lot as he got out of the car. The court found that the plaintiff, his name was Mr. Lear, was not wearing footwear appropriate for winter weather conditions, and he was not keeping a proper lookout. In that instance, there was two other people that fell at the same time and on the same parking lot as the plaintiff, but they were wearing safety boots, and the court noted that these other two individuals were not injured, so wearing the proper shoes was causally connected to the plaintiff's injuries. And the court determined that the plaintiff was 25% liable for their own injuries. In a case recently in the city of Hamilton in 2015 by the name of Bramer, confirmed that running shoes are not an appropriate winter footwear and constitute contributory negligence, and referred to another decision earlier in Saskatchewan in 1999. However, the court noted that footwear was only one factor in the finding of contributory negligence. In this case, the court rejected the contention that the plaintiff was contributory negligent for wearing running shoes, because many people walking that path also used running shoes, and the court took judicial notice that running shoes have a tread pattern on them, and noted that the plaintiff was being careful. And in that instance, the plaintiff was not found to be liable whatsoever for the footwear they were wearing. So the conclusions that we draw from these cases are several. One is that running shoes may not be an appropriate winter footwear and can constitute contributory negligence if they're worn during winter conditions where a plaintiff has slipped and fallen. Secondly, wearing extreme heeled shoes is often criticized because they don't provide the most stable foundational support to those who wear them, doubly so if worn outside during wintry conditions. Thirdly, flip-flops are known as footwear to be shoes which are not very slip resistant, and it's likely that a plaintiff will be found contributory negligent due to their footwear if the footwear was inappropriate, or if the occupier of the premises could not have reasonably expected the persons entering the property to wear shoes with less support and less tread, like flip-flops. Fourthly, whether wearing flip-flops was reasonable for the plaintiff to do or not can depend on where they're worn. For example, a plaintiff may be found contributory negligent for walking on a construction site with flip-flops, but not be found contributory negligent for falling over a crack in a city sidewalk near a public beach, where such shoes are typically worn. It is incorrect to say that wearing flip-flops will inherently remove the liability of the defendant, or that it automatically results in a finding of contributory negligence. Every case does rise or fall, pun intended, on the facts. Fifth and lastly, in cases where a plaintiff has had a slip and fall accident and was wearing proper footwear that was related to the injury suffered by the plaintiff, then a good estimate of contributory negligence based on the case law is about 25% if that footwear is deemed to be inappropriate. So it's one thing for the plaintiff to argue that the footwear is appropriate, but depending on the exact nature of the footwear and the conditions under which it's being worn, the court may find to the contrary. So the moral of the story is be careful of the shoes that you're wearing because it could cause you to fall. And by the way, if you have fallen and you think you have a claim, we always recommend to our clients that they preserve that pair of shoes or boots. Don't wear them again in case the matter does go to trial and we have to show that to the jury or to the trial judge. We want them in the same condition they were in when you fell.